Chief Justice, Justices, I wish to begin my submissions by asking you to go to our condensed book at tab A, which is an outline of our argument. And I want to spend the first 8-10 minutes on the test that we propose and why this particular proposed test is one that is sensible and ought to be adopted by the court. And this is the first paragraph of our outline. And this is, as I say, the legal test proposed by the respondent. This is the test that is in substance the one that was articulated by the Ontario Court of Appeal. In our submission, it's the only workable test that is commensurate and proportional to the purpose and objectives of the legislation and fairly responds to the early stage in which the anti-SLAPP motions take place. This test also ensures that this legislation does not become a safe haven for defamation. This test ensures that it will prevent powerful and well-funded defendants, like the appellants, from using the anti-SLAPP legislation for, in our submission, an improper purpose, which effectively weaponized the procedure to gain an enormous, unintended tactical and procedural advantage that prevents innocent libel victims from vindicating their names. This concern of using this legislation for unintended purposes is exactly what the Quebec Court of Appeal in Kepler warned against, which is discussed in our factum, as well as the Advocate Society. And so the very concern that they raise is exactly what we have in this case. This test also acknowledges the existence of the type of evidence that is certain to exist, but is simply not available to a plaintiff in time for a screening motion. And so the test prevents giving defendants a windfall, that results in a premature dismissal of an action. We have a significant fresh evidence motion before you. I have limited time. I'm certainly comfortable with all the written submissions we have with respect to the fresh evidence, but I want to make this point. That instead of referring to hypotheticals, you have real facts, real evidence, which I am confident that the court will find was impossible for Dr. Platnick to have in time for his anti-SLAPP motion. But because of other parallel proceedings that were going on, significant evidence going directly to the merits has now been produced. And I urge the court to look at our 5-page reply submission with respect to updating the fresh evidence, which is a case in point, because it was the appellants who put the parallel Carpenter proceedings into evidence, where there are very serious allegations made against Dr. Platnick. And they put it into evidence, and they leveraged it to maximize maximizing discrediting Dr. Platnick. But the fresh evidence now shows that we've had examinations for discovery in the Carpenter action. Some 16,000 pages were produced by Dr. Carpenter, 8,000 by the insurer. And what the fresh evidence shows is that all her allegations were completely without merit, and ultimately, when confronted with that fact, she unconditionally abandoned her case against Dr. Platnick.
Danson, when you say that it was impossible for your client to get this new evidence before, is it because the evidence did not exist, or it is just you did not have the time to get it?
We had 25 days to file our responding materials. This was, by and large, evidence that was not in Dr. Platnick's possession or control. It was in the possession of other people.
But it was evidence already existing.
It was evidence that was existing in the hands of other parties, okay, which we were only able to access realistically, because it's not a summary judgment motion, the point has been well made, until we got into those proceedings and were able to get productions which they had no choice but to give to us. And the fresh evidence summarizes that evidence and shows how overwhelming the case Dr. Platnick has against Dr. Carpenter, and that the allegations against him were false. In our submission, that while the test that we propose is the one that we urge the court to adopt, we also submit that that regardless of what test this court decides is the appropriate one, Dr. Platnick's case survives based on the facts. The particular ones I want to emphasize will be, I'll get to in a moment. But our proposed test also preserves one of the most sacrosanct and precious rights integral to Canadian democracy, and that is access to justice, the right to be heard fairly, the right to have your day in court, and have an opportunity to fairly and sensibly develop a reliable evidentiary record. And so, in my submission, when you have a case like Dr. Platnick's, and I think it's irrefutable, but his libel action, in every sense, is an honest, genuine, good faith, bona fide libel action. And if this type of legitimate libel action cannot survive this anti-SLAPP screening motion, then no libel action will, and libel law will be dead in Canada. And Canadians need this court to protect them from those who deliberately and recklessly destroy their reputations.
Your colleague mentioned that there were no allegations against learners in your proceedings. What do you have to respond?
Well, my response to that, Chief Justice, is this. Ms. Bent was acting as a partner of learners. She is speaking about a learner's client. She's using learner's letterhead and using learner's email address. To separate the lawyer, Ms. Bent, from her firm and their client is one that I submit is untenable and takes this case beyond just being vicariously liable for Ms. Bent's conduct.
So is there a specific pleading in your statement of claim regarding learners?
Other than in the context of Ms. Bent being a partner. Yeah, I don't have it at my fingertips, but I think in the context of learners being the partner, and we do plead the statement showing that it's on learner's letterhead, learner's client, learner's email address. I think that is sufficient. Of course, one of the problems with legislation, you're not even allowed to amend your statement of claim without leave. And in this case, our statement of claim was drafted before this legislation even existed. And Justice Dunphy wouldn't even give us an opportunity to amend the pleading.
You've got a limited amount of time, and I just want to signal to you, deal with it now, deal with it in your own good time, but I'd really like to hear from you on qualified privilege.
Yes, I'm going to address that 2 points from here, because that's actually one of the most important parts of the submission. But I wanted just to close on the efficacy of the test that we put forward, is that this court has repeatedly held that a person's reputation is their most valued and prized asset. And so, in my submission, enormous caution must be exercised before an action is arrested on a preliminary procedural screening motion. It is counter to everything that our justice system is based on. I now want to take you to tab 1 of our condensed outline. And I'm going to start where Mr. O'Sullivan ended, or near ended. And that is to the last sentence and that's on page 4 of tab 1, where Ms. Bent writes, "This is not an isolated example, as I had another file where Dr. Platnick changed the doctor's decision from a marked to a moderate impairment." Now remember, this is going to a very discrete group of people. It's going to plaintiff personal injuries lawyers, and it gets out, as we know, to the insurance industry that deals with accident benefits and whether a person meets the test for catastrophic impairment or not. So it's a very distinct group, and this went viral. Mr. O'Sullivan says there's no evidence. This went viral within 2 days of this being disseminated to 670 plaintiff personal injuries lawyers, and within weeks the process of being blacklisted began. So before any republication, Dr. Platnick's career was crushed. His business was decimated. You couldn't have greater harm as a result. What Mr. O'Sullivan said, it's just one sentence. This is the one sentence that destroyed Dr. Platnick's life. To the audience who was receiving this, this is tantamount to an allegation of fraud. The allegation is that Dr. Platnick changed another doctor's conclusion without that doctor's knowledge or consent from a catastrophic determination to a non-catastrophic determination. So it's no wonder that this went viral, and it's no wonder that Dr. Platnick got blacklisted and his career crushed.
Mr. Danson, can I just stop you on the no wonder it went viral? I appreciate that that was part of Justice Doherty's reasons. This was a listserv that involved only lawyers. Am I right about that?
Yes.
And there was an undertaking by all of those lawyers that they would not reveal the confidential information. Where then do we find ourselves entitled to conclude that it was likely to be released simply because it was on the web? I mean, what is the basis for concluding that lawyers would violate their own undertaking to another lawyer?
I'm going to give two answers. One immediately, and then the next one, a question I anticipated is at my next tab, if I could answer you also with that document in front of you. But my first is, and I'm not trying to be facetious or sarcastic, but if you talk about an air of reality, if you want to keep a secret, the last thing you do is tell 670 plaintiff personal injuries lawyers against a respected defense expert who they would like nothing better than to get rid of. And so I just submit, just on the air of reality, you can't possibly think that you could communicate so widely.
Well, as a former occasional plaintiff lawyer, I do think that you may be underplaying the significance that they've all given an undertaking. I'm struggling with this point too, and so maybe if you could account for that. Why should we, notwithstanding them having given an undertaking, we all know what we learned in the bar courses about undertakings, should this have been foreseen?
Okay, so I'm going to, in 30 seconds I'm going to come to it, because I think the best way to answer both questions is in the next document. But just to finish off the libel, is that and I urge this court to adopt the language of the Ontario Court of Appeal. This last sentence that devastated Dr. Platnick's life, as the Court of Appeal said, was an unambiguous allegation of dishonesty and professional misconduct that was not accurate in any sense. And it's also completely unrelated to the subject matter of the occasion, which is the rest of the email that was dealing with the Carpenter matter. And we also know from the evidence that, this is significant and it's in my outline at tab number 1 on the outline, as the Court of Appeal said, Miss Bent, she had no knowledge of the interaction between Dr. Dua and Dr. Platnick. She went back by memory over 2 years earlier, never consulted her file, never consulted Dr. Dua, never consulted Dr. Platnick or the lawyer on the other side or the vendor company or the insurance company. And as you see documented in our factum, she was saying that she remembered this from years earlier and that she was shocked, she was appalled, it was deplorable and should not be tolerated.
And she was wrong, so her justification defense is out the window. But we're in qualified privilege, right? You say it's completely unrelated to the substance of the allegations. Okay.
So if I could go to that question directly, and Justice Abel, to tab 2, because this is the governing document of which is the undertaking signed by the OPLA members, and it makes it very clear, and the Court of Appeal did not say that the listserv was a privileged occasion. What they said, and I think it matters, is that for the purposes of their reasons only, they were prepared to assume that the occasion was privileged. And then they go on and give the reasons effectively that you exceeded the occasion and there could be evidence of malice, and therefore this should go to trial. It's almost impossible to determine malice on a preliminary screening motion. It's even difficult at trial.
But how does even the inference of malice arise from a set of circumstances where a lawyer is using a confidentially protected listserv that she expects, based on experience and the fact that she's dealing with lawyers, will be kept confidential? How does that then get transformed into an intent to be malicious because one person in the listserv circulated the email?
Okay, well, we of course don't accept that it was just one person who disseminated the email. And as you see from the record, when we asked Ms. Bent to name the leaker so we could test that, we were denied the right to know the leaker because this wasn't a discovery.
But I thought the evidence was that it was one person, and then it went viral after that.
Well, that's what the allegation is, but when you're in Dr. Platnick's shoes, you don't really know that. And that's why we asked to identify the leaker so we could challenge that, and we were not even allowed to challenge that on this motion.
Sir Danson, we know that as soon as your client became aware of the content of the email, he asked for an apology or a retraction, and that was not given.
Correct.
Does it have any bearing on this case?
Yes, I think it does very much because of what I submit is the overarching purpose of this legislation, which is anti-SLAPP legislation. And this is a case where Dr. Platnick and Ms. Bent didn't even know each other. And when he sees his life falling apart, he reaches out to them and says, let's talk about this. You can see from the record that the letter that he wrote is that he wanted a retraction or an apology from Ms. Bent and learners, just circumscribed to the people who received the email and to those people who hired Dr. Platnick and blacklisted him. And you saw from the pleadings of Ms. Bent, she says, we don't need to do that, and they didn't. And so this is the antithesis of everything that the legislature had in mind in passing this legislation.
Why do you say that, Mr. Danson? What do you say the purpose of the legislation was? You argued that it was in breach of access to information. I thought that was a constitutional challenge that was unsuccessful under Section 7.
Yeah, the purpose of this legislation, in my respectful submission, is that it is to target essentially, not exclusively, but essentially, strategic lawsuits that are aimed to suppress expression on matters of public interest. And in our factum, we detail and we've sidebarred in all the Hansard debates, the Attorney General's report, the Downard article, who was one of the architects of the legislation, all confirm this, and they also confirm that they're not prioritizing freedom of expression they made it very clear that the law of defamation does not change. And so therefore, even under this test, under this legislation, the court has to apply the law of defamation as this court has articulated, where there isn't a hierarchy of rights, but a reconciliation of rights based on the particular facts. And so there is no prioritization.
What do you make, though, of the 4 subsections in 137.1.1? I'm not seeing anything mentioned in there except expression, protecting expression. It seems to me that protecting expression and protecting from libel are 2 different concepts.
Well, because there I submit that you do need the assistance of the legislative debates, the Attorney General's report, and the authors who participated in drafting this legislation, who make it clear that the substantive, and I reference this in my factum and where you'll find it in the materials, that they are not changing the substantive law of defamation. And so if you're not changing the substantive law of defamation, but you're targeting the strategic lawsuits that can be abusive, to bully and intimidate people into silence, then those are the ones that should be screened out on this procedural screening motion. But if the law of defamation remains, I don't mean to be repeating myself, but that means that there is this reconciliation of free speech versus protecting reputation, and that is built into the legislation.
So where does that leave sub 4, and specifically the balancing under B? Doesn't it suggest that even if there is even if there are grounds to believe that the proceeding has substantial merit, and that the moving party has no valid defense, even if, which essentially means defamation in another context, I would say, what's the point of the conjunctive and to suggest that you still have to go on to look at the competing harms?
Well, that's obviously the one of my only criticism of the Court of Appeal, because I otherwise asked the court to fully endorse the decision, is that they moved the anti-SLAPP aspect of the test to the harms test under sub 4. And you see from my factum, I submit that this is highly relevant to the substantial merit of the claim to begin with, and so that should be at the front end. But this legislation is different in that sense, where you can find that there is the plaintiff has a substantial cause of action, that there are no valid defenses, but nevertheless, you could still lose on the public interest balancing.
In other words, even if there is defamation, you can still lose.
Well, it would appear the way this legislation is drafted, yes. So that's why the test that the Court of Appeal put forward, I've modified it slightly in ours, is the right test so that you can get to 4. Otherwise, if the test is too high, you don't get into these important public policy considerations, which is the most important. Is it in the public interest that this lawsuit go forward? And if you put the test too high at the front end, you never get to what the Court of Appeal says is the heart of the legislation. So if the Court of Appeal is correct, if this Court agrees that the Court of Appeal is correct, that that is the heart of the legislation, that public policy, public interest balancing, then it's critical that the test that we urge the Court to adopt is the reasonable one, because then otherwise sub 4 becomes poetry. You never get to it.
At paragraph 21, that same point, paragraph 21 of your factum, you say, like the Ontario Court of Appeal, the Quebec Court of Appeal describes slap actions as actions that attempt to defeat the ends of justice, thereby constituting an abusive process. The Quebec Court of Appeal may have said that, but is it relevant that that expression, defeat the ends of justice, is at the core of the equivalent of 137.1 in the Quebec Code of Civil Procedure? In other words, the rule that you propose to place at the core of the Ontario rules is not present, at least not explicitly so.
Well, certainly going to the core of the administration of justice it would appear that the legislature has put that into sub 4.
Well,
I don't know if that answers.
no, it doesn't. So it was respectfully. It's this idea that the defamation action is taken with a view to subverting the ends of justice. It is an abusive process inherently. That's what the Quebec regime, the other regimes in North America, are predicated upon. Is that the same as the Ontario regime, which does not appear to speak directly to that value, and the advisory group suggests that it wasn't front and center on their minds, at least as I read it?
Well, my response to that is that it is highly relevant to whether the case has substantial merit. When you look at the purpose of the legislation, which is overarchingly, not exclusively, is to screen out abusive slap actions. In the substantial merit aspect of the test, when you see that as not at all what this litigation is all about, then that is very significant, relevant factor. It may not be expressed as the same way in the Quebec Code, but I submit that it's highly relevant in the first step of the analysis in terms of substantial merit. And then when you turn to the defense then has to be proportional to that. And that's why the wording of the Court of Appeal and the test that we put forward, I submit, is the most sensible and workable test.
I would have thought in the libel case, it's not so hard to show that there's a lot of merit if all you're looking at is not the defenses at that point, but just the pleadings. Justice Doherty sort of makes this clear. He says it's easy here. We just look through step 1, 2, 3, we got it. So if you've got it without looking at the defense, not so hard to prove substantial merit if that's all you're looking at. I'm more interested in what you say the second part means, the defense isn't valid.
Well, my submission, Justice Maldaver, is that, not to repeat it, but the test that you see in our outline in the first paragraph is the proper test to measure against the defenses, recognizing that this is a preliminary screening motion, so that it has to have the flexibility of being within the range of conclusions reasonably available to the motion judge, recognizing the gatekeeper role that judge is playing. based on the evidence that's before them and the submissions of counsel as to whether or not there is a reasonable basis to conclude that there's no valid defenses. Otherwise, this effectively becomes a test of a summary judgment motion on a screening motion under disguise, and that was the concern of the Court of Appeal, that it not slide into that.
So you were going to tell us something about the undertaking.
Exactly. You read my mind. I said I got 4 minutes and 47 seconds, so if I could turn to that, because this is obviously a very important point. So at tab 2 of our is the undertaking, and what I wanted to focus the Court's attention is to the first sidebar under listserv use. So the OPLA itself says that they agree and that my use of the listserv will be restricted to issues arising on ongoing files in relation to existing or contemplated litigation and for the purpose of obtaining counsel, advice, and assistance in connection therewith. That's the use. That is the limited, restricted use of the listserv to which the confidentiality clause applies. Because if you go to my next sidebar, they say, I undertake and agree that I will actively assert privilege in connection with any listserv communication on the basis that such communications are subject to a claim for litigation privilege, not qualified privilege. OPLA got it right, because they're talking about the sole use of the listserv is to talk about ongoing or contemplated litigation, and so therefore clearly you have solicitor-client concerns, you have litigation privilege. So the confidentiality, they can't cherry pick it. I know this is also, Justice Abella, to the question you're asking, is that the confidentiality doesn't apply at large. Confidentiality applies for the expressed and restricted use of the listserv itself because of solicitor-client privilege. And then, to avoid any kind of ambiguity, is the next paragraph where there is a expressed prohibition against using the listserv for material that are or may be defamatory. So again, obviously it can't be a matter of qualified privilege, because the benefit of qualified privilege, as Mr. Winkler says, so what if it's not the truth? The occasion is qualified, and therefore you can't be sued if you libel someone. But they can't use this document, which they are, to make that argument when there's an express prohibition of doing exactly what they did. And I would submit that in Grant and Torstar, where this court raised the issue of qualified privilege and said that qualified privilege, the threshold is a high one, but you didn't need to determine what that was in Grant and Torstar because you then developed the responsible communication test. Well, maybe this case raises it front and center, what is that high threshold? And the mistake that many people make with respect to qualified privilege, this may be very important to the plaintiff's personal injuries bar. That's not what defines whether the occasion is privileged. It's the societal values, it's the public interest that determines whether or not the fact that lawyers want to talk about trial strategies among themselves, not to the general public, is a matter that will attract a qualified privilege. In my respectful submission, the high threshold this court referred to in Grant and Torstar will not cover this specific use.
What about the first paragraph under the heading confidentiality, which is much more general? I undertake to keep all listserv information, opinions, and comments strictly confidential from all others, including CLAVA members who aren't listserv members.
Justice Brown, my response to that is that clause has to be read in the context of the use of the listserv itself. I'll just be repeating myself, but because the confidentiality cannot apply to a prohibited purpose. The listserv is so clear and categorical that you cannot use this for any other purpose than what we say, and for sure not defamatory material, and then engage in a serious defamation that decimates a person's life, wipes out his ability, his entire career, and then say, well, I got this confidentiality. And if I could just ask the court, because I know I'm to 41 seconds.
I would like to ask a question on another matter that goes back to what you were talking about in terms of, you were arguing the purpose, you were looking at the reports and some of the legislative history.
But in this particular instance, we have a purpose clause that has been explicitly introduced into the legislation. And how do you deal with the fact that a unique feature of this legislation is that we have 137.11 that articulates 4 purposes of this that are very different than the purposes that you're arguing are motivating this legislation?
Well, my response to that is that the promotion of expression on matters of public interest are matters that are truly in the public interest. In this, on the facts of this case, the expression was confined to what they call is a confidential private listserv just among those lawyers. And I would first admit that that's not the kind of expression of public interest at large that the legislation was responding to. But I still come back to the Hansard debates, particularly this is in my materials, the speech of the Attorney General of Ontario when she introduced the legislation, and the AG's report is so clear that what its purpose is, and it really was directed at strategic lawsuits intending to bully and intimidate people into silence. And this is the antithesis of that. And so, again, I apologize for repeating, but those same debates and the Attorney General's report is so clear that the substantive law of defamation is not changed. It just means that in these abusive cases, we're going to screen them out early. But otherwise, the law of libel and slander applies. And the Attorney General, introducing this legislation, makes it clear the premium that we as a society, and what this court has said, is a matter of vital importance to Canadians to defend their reputations. And so to use this legislation to silence legitimate libel cases like this and have a high threshold, that's why I said earlier, the effect of my friend's argument is that libel law will become dead in this country if a libel suit like this can't go forward.
Thank you very much.
Thank you.
The court will break for lunch. We'll be back at 1:15.
Appétit.